So, if you look at the international legal literature, this is one of the quotes that you'll find most often. So it's by the late Louis Henkin, and he says that it's probably the case that almost all nations observe almost all principles of international law, almost all of their obligations, almost all of the time. It's quite a positive message. It's quite a positive view on compliance in MEAs. But the question is, of course, why do some countries, so if we're not talking about all countries, why do some countries sometimes not comply? The two main schools that you see in the compliance literature is let's say, what's so-called the enforcement school and a so-called managerial school. So the enforcement school basically sees states as rational actors, basically suggests that states will make a cost-benefit analysis, how much is it going to cost us to comply, and if the cost exceeds the benefits of compliance, they will not comply. So basically they suggest that if there's no sanctions that would add to the cost of compliance, states would not comply. Very, very basic explanation, and referring back to what one of you said about the cost of participation. Then you have the managerial school, which sees states as much more innocent or innocuous, and suggests, well, non-compliance is not a reason. The reason for non-compliance is not that states make this calculation, but rather they want to comply, but sometimes they simply do not have the capacity to comply. There's too little time, so the deadlines set in MEAs might be too stringent, or sometimes it's not even clear what the actual norm is that a state needs to comply with. So here it's seen as a much more different reasoning or different explanation of why states do not comply. And there's more theories and more explanations, but I just wanted to highlight the third one as well, which is from an international law perspective, it's about the legitimacy of the norms in MEAs. So if these norms are created through a process with which a state did not really agree, or that a state was not really involved in, the state might not feel any need to comply with that norm because they haven't internalized it through the process. So this is the work of Tom Frank, for example, which has referred to this as well. So there are other explanations as well, and also what you should remember is that none of these explanations is sufficient. And none of these explanations is also not necessarily exclusionary of the other explanation. So it might be that states do to some extent have an analysis of the cost and benefit, but it might also be that in some cases there might be a lack of capacity or a lack of time for a state to comply. So none of these theories is necessarily fully explanatory of all instances of non-compliance, but these are some of the reasons. So under the enforcement school, it's about raising the cost of non-compliance by putting in place sanctions, by putting in place penalties if countries do not comply. That's one of the measures that enforcement school would suggest. Then under the managerial school, it's again, well, if we have a lack of capacity, we need to build capacity, as Julie was saying, or we need to provide technical assistance for monitoring and other processes, or in the end, more broadly, we need to facilitate implementation for these countries. And if you take the legitimacy point of view, well, the norms that you're talking about need to create it through a fair process. Only then will a country internalize those norms and actually comply with them. So again, none of these explanations and none of these suggestions is necessarily exclusive or is necessarily the one right answer, the one true answer. But all taken together, you provide, let's say, the broad spectrum of reasons why countries do not comply and the mechanisms and the measures that MEAs can take to induce compliance. So again, to just list a few of the measures that MEAs can employ in promoting compliance. So focusing more on the enforcement side, and again, the distinction between enforcement and facilitation is not always crystal clear. It's not always black and white. But let's say if we're focusing more on the enforcement side, we're talking about possible trade bans, as is used in some conventions like the Montreal Protocol and CITES. We're talking about withdrawal of benefits. So if you do not comply, you will not get the benefits that you were originally getting under the convention, or suspension of rights is another measure like this. Naming and shaming, so the political embarrassment that we were talking about. So basically saying this country did not comply with that obligation might be one way of at least inducing a government to comply in the future, because it's basically seen for the rest of the world, but also for its domestic actors, for civil society, as non-compliant with its international obligations. Or financial penalties. Again, these are some of the examples that have been used in existing MEAs. But then focusing more on the facilitation side, we can again talk about capacity building. So make sure that countries actually have the institutional capacity to implement the agreements and to comply with their obligations. We can talk about financial and technical assistance. We can help countries to think about, okay, you're in non-compliance now, but how do you intend to return to compliance? So making a compliance action plan is one example. And finally, as was mentioned already, providing detailed guidance on how countries can comply. This is certainly not an exhaustive list of measures, but it's quite an illustrative list. So to give you a little bit more practical or tangible ways of how this can be included through MEA processes, this is just one example from the CITES compliance mechanism, where you see basically that the standing committee in this case has quite a lot of measures at its availability to make sure that countries comply. And some of them are focusing more on the facilitative side, so we're talking about capacity building, in-country assistance. Others are already moving slightly more towards, not necessarily an enforcement side, but at least already a little bit of naming and shaming, so a public notification of what a party has been doing, or issuing a caution, which in international environmental agreements might already sound quite negative. So there's a number of ways that MEAs already are employing in their compliance mechanisms.